Okay, we're just about on schedule. So welcome everybody to this webinar hosted by Cleveland Scott York. My name is Adrian Bradley. I'm a partner on the life science team here at Cleveland Scott York, and I am delighted to welcome today's guest speaker, who is Dr. Lawrence Cullen, who is a leading authority on the complex intersection of patent law, regulatory frameworks, and pharmaceutical innovation, and most germanely for the topic of today's talk, supplementary protection certificates. Lawrence has more than 25 years of frontline experience shaping how intellectual property is examined, granted, and defended across biotechnology, chemistry, and pharmaceuticals. He has been at the center of some of the most technically demanding and legally significant questions in modern life sciences IP. As former Deputy Director for Biotechnology, Pharmaceuticals and Organic Chemistry at the UK Intellectual Property Office, he oversaw specialist scientific teams, directed patent examination strategy, and was involved in one of the most influential decisions, some of the most influential decisions regarding patents and supplementary protection certificates. Today, he brings his unparalleled experience to a topic of major practical importance: supplementary protection certificates and what the CJEU's recent combination product judgments mean for innovators, regulators, and rights holders. These decisions have reshaped the SPC landscape, and there are few people in the country better placed to explain their implications than Lawrence. So Lawrence, the floor is yours, and we look forward to your presentation. What I would say, if you have questions, Lawrence has kindly agreed to have a question and answer session. If you put your questions in the chat panel, then I can put these to Lawrence at the end of the webinar, and we can all benefit from his answers. So enough of my waffle, over to you, Lawrence, and we look forward to hearing your thoughts.
Great. Well, thanks, Adrian. Thanks, Cleveland Scott York, for the chance to talk this afternoon. I have put a timer on because I want to try and stick to 25 minutes for the talk to make sure sometimes some questions, sorry. So if my alarm goes off, hopefully that's the reason why. So just by way of introduction, the topics that I want to cover are these. I'll say a little bit about my experience, but Adrian's adequately covered that already. There's just one or two further points I'd like to make. Then we'll talk about the meat of the presentation, combination products. And I apologize if I get enthusiastic about the subject. I find it fascinating and really interesting. And then at the end, I'll just pick up one or two points that I think are worth watching to see how they develop going forward. So I was a hearing officer at the UK Patent Office. I was involved in 50 decisions to do with SPCs that covered 79. Sorry, there were 50 decisions. There are 50 decisions at the office that cover SPCs dealing with 79 SPCs themselves. I did 27 of those decisions. So I've had a lot of experience. And the main reason for that is because I was in charge of the group that dealt with the biotech and the pharma and the chemistry patents. They're the basic patents for these. And so we had the basic expertise to deal with the SPCs. Now, of those 50 hearing officer decisions, 17 of them were appealed to the UK courts. And those 17 dealt with 50 SPCs. So a lot of those were actually combination cases, going back to the original series of cases that I will mention briefly when we come on to talk about Article 3. And of those 17 cases, 13 of them ended up in the Court of Justice of the European Union. So if you like, 75% of those cases that were argued before the UK courts ended up going to the CJEU. Now, as another interesting statistic, 5% of all the granted SPCs in the UK have ended up being appealed. So I suppose that reflects the value of these rights to the respective owners, and that it's worth, if you like, asking the questions in the courts to see what's happening, even if you're you know, aware that there might be some issues with your case. Now, it's also the case to say that the UK has been the source of a significant number of the referrals in the period 1994 to 2020 before we left the EU. So clearly, the UK courts has been concerned with the regulation and how it's interpreted, and it's been of interest to industry and stakeholders in the UK significantly. But now that we're out of the EU, it'll be interesting to see whether that trend continues. So moving on to the topic, what we're interested in is the conditions for obtaining an SPC. These are governed under Article 3 of the SPC regulation, and of particular interest for working out what we can grant is 3A and 3C. The product is protected by a basic patent. It has a valid authorization. The product has not already been the subject of an SPC. And now I've just said in accordance with the relevant legislation here, because before EU exit, this was the relevant directives in the European Union, which I think people will be aware of. But post EU exit, this regulation has been brought into UK law, and it's the relevant legislation in the UK that applies. So, we can provide the detail of that if necessary. But I'll be focusing more on the discussion around 3A and 3C this afternoon. What I've also included here are the relevant cases from the Court of Justice of the European Union, which relate to each of these topics. 3A and 3C, you will see, have generated quite a bit of case law, particularly 3A, in working out what is actually protected by the basic patent. And of course, as patent practitioners, we always think that we know what protected by the patent means. But that's for the purposes of the patent. In SPC practice, protected by the patent means something different. The SPC is a separate right. It extends the patent, but it only extends the patent in relation to the product that has been authorized for use in a medicinal product. And this is the source of a lot of the questions and the interesting topics that have been written. So how we work out what protected by the patent means for the purposes of granting the SPC. So the case we'd like to speak about is the combined case. So I've referred to this as a combination of referrals and combinations. This was the two Merck cases, one that came from the Finnish courts, one that came from the Irish courts. And basically the question that was being asked is, could you have an SPC for the combination if there was an earlier SPC for the single product? So in the Finnish case, the combination was sitagliptin and metformin for the treatment of diabetes. And in the Irish case, the product was ezetimibe and simvastatin for the treatment of cholesterol and lowering blood pressure. And one came out of an infringement action that went through the courts, and one came out of a declaration of invalidity. So both of these cases were combined. Now, part is that because they had some common features. So the combination of the inventive compound was explicitly claimed. So simvastatin with ezetimibe and metformin with sitagliptin, both of these were actually claimed in the respective basic patents. Now, there was some discussion about the relevant case law in both cases, and it appeared that Activas 1 and Activas 2, which had been cases that referred to 3C, were suggesting a different approach, and that Teva, which was a case in relation to 3A, was suggesting an alternative approach. And that was one of the areas that needed to be resolved. And the two basic issues were a combination of A plus B is different to the product of A or B. I think that was the key question that was being asked in both cases, and both referring courts said they thought that it was. And that the meaning of product in relation to 3A and 3B should be the same. So Now, I'm not going to dwell on these questions. They're pretty complicated. But what I will say is that the questions from Finland all related to 3C, right? So that was how to work out if the product has been protected by an earlier SPC. And it made specific reference to the case law that I mentioned. So Actavis 1, Actavis 2, Teva, and another case, royalty pharma. So the court was asking fairly complicated questions, trying to understand how the case law should be applied and some of the concepts that were in that. And in the questions from Ireland, these were two of them were in relation to 3A, and two of them were in relation to 3C. And again, these were quite detailed questions, trying to work out how you actually understood the application of 3A, and then working out whether you could grant an SPC for something which contained at least one of the same, which contains one for a combination which contained one of the components which had already been granted an SPC. Now, the Advocate General in this case said that basically the approach should be 3A is referring back to earlier case law. So this is Teva versus Gilead. We'll talk about this in a little bit more detail in a minute. But he said the basic requirement, the test for 3A, was that the product must be expressly mentioned or specifically identifiable in the claims, but it also must fall under the invention, which is the subject matter of that patent. Now, I suppose fall under the invention is something, it's a concept that has been developed in relation to SPCs, and it's been consistently used. It certainly generates some debate and kind of illustrates the point why protected by the patent for the purposes of 3A does not mean infringement, which is kind of our standard understanding of what protected by the patent means in relation to the patent itself. And then for Article 3C, the Advocate General proposed that the earlier concepts from the previous case law, like Actavis 1 and Actavis 2, which talked about you needed to work out whether the product that had been the subject of an SPC previously was part of the core inventive advance or the subject matter of the invention. He said that's actually irrelevant for the purposes of assessing 3C. So the direction he was pointing is that, if you like, 3A was working out what the product actually was, what was disclosed and what was protected by the patent, whereas 3C did not have those same kind of considerations as part of it. That was the implication. And the Advocate General went and looked at Article 3C first, and then clarified that, and then went to look at Article 3A, because that involved a lot more discussion and explanation of the concepts in order to come to the conclusion that he wanted. Now, I won't dwell in any more detail on the Advocate General's opinion, but in this instance, the court was, I think, heavily influenced by the Advocate General's approach and adopted a similar way of looking at things. So the substantive, the judgment in the combined case had the three operative parts. They dealt with 3C first, and I've summarized this as saying that A plus B is not the same product as A or B, which was one of the common features that the referring courts have made. That's clear. But in relation to 3A, so 3C was purely a question of if you're trying to work out whether you can have an SPC for a combination, the fact that one element of that product has already been the subject of an SPC, and the second element is something that's more known, that's not, those kind of conditions aren't relevant, because A plus B is a different product to A or to B. But in 3A, it said that it was referring back to the fact that the general test that had been developed in Teva versus Gilead, it said that, well, it's not sufficient just to be in the claims of the patent, right? it must also, and here's this term again, fall from the point of view of the person skilled in the art and in light of the description and drawings of that patent under the invention covered by that patent at the filing date or the prior date. So clearly there's something about what's actually disclosed in the patent over and above the claim. So there has to be, it's not just sufficient to claim it. It has to be linked to actually what is the innovation, if you like, that the patent is describing. So this was reinforced in the third paragraph because they said the product A plus B must be disclosed as meeting the subject matter of the invention. Now, I've chosen subject matter here as a way of trying to avoid using fall and to try and get across that the patent is describing the invention and it's what is in that disclosure in terms of the claims, the description, the drawings, that says that A plus B is also meeting the invention that the patent relates to. So I think this may be the take-home message that I would encourage everybody to take on in terms of how Article 3 works. There are 4 conditions set down in the article. Now they are cumulative. Each of them applies separately, but they all add up together. And if you fail one of them, you don't meet the requirements to grant the SPC. And the court itself explicitly referred to some of the earlier case law and to the Advocate General's opinion in making that clear. And he says that each of these conditions has its own logic and objective. And a quote from the judgment is there, which is said that the logic and objective, which would be compromised if these conditions were to be confused or merged. In particular, the conditions set out in Article 3A and 3C cannot be confused or merged without compromising the legal certainty and the balance of interest sought by the EU legislator. And I think the best way to summarize this is that Article 3A delimits the material scope of the SPC by reference to the basic patent. So what does the actual SPC cover? What does it protect? Whereas Article 3C sets a limit to the temporal scope of the SPC on a given product. So if you apply for an SPC and there is an earlier SPC for that product, then you won't be able to get another SPC because the timing or the reward or the extension that you're entitled to has already been granted in relation to the earlier product. So I've mentioned Teva versus Gilead a couple of times, and I think it's worth just reminding ourselves what this said. Sorry if people have been a little bit, haven't quite remembered the details on this up until now, but I thought it was just worth referring to a bit more detail here. So it sets out a 2-step test to determine what protected by the patent means under Article 3A. Now, this is a Grand Chamber decision. So basically all 15 judges of the Court of Justice of the European sat and made this decision. And I think it reflects the view of the court that they needed to give as authoritative a decision as they could in order to give a view on Article 3A, given the amount of case law, the number of times they had been asked to look at this question of what 3A means, principally by the UK courts, but not only by the UK courts. So in the Teva versus Gilead case that they looked at, the combination itself was not expressly mentioned in the claims of the basic patent. So in the present cases, as I said, the combination was claimed. So that basically means, if you like, that there is that one of the limbs of the steps in Teva versus Gilead, that it needed to be specifically identified or claimed in the claims, was actually met in the 2 Merck cases. And so one of the questions was, well, is it enough if the combination is expressly mentioned in the claims? And the court said, well, it does not suffice that the claims of the patent relate to that product expressly and specifically. It is also necessary, in order to satisfy the conditions laid down in 3A, that the product fall under the invention protected by that patent. And it referred specifically to the judgment in Teva about this. So in a sense, it's saying that there is two steps, and you must in the test from Teva, and you must meet both of those steps. So this is how I've summarized it here. This is the actual the test directly taken from Teva. So for the purposes and from the point of view of the person skilled in the art, and on the basis of the prior art at the filing date of the prior state of the basic patent, the combination of those active ingredients must necessarily, in light of the description and drawings of that patent, fall under the invention covered by that patent. And each of these active ingredients must be specifically identifiable in light of all the information disclosed by that patent. So specifically identifiable, if it's claimed, then I think we would be comfortable with the idea that it's specifically identifiable. But the combination of the active ingredients must necessarily, in light of the description and drawings of that patent, fall on the invention. So this is the term that the court has settled on, and we'll look at this in a little bit more detail. As we go forward. So the Teva 1 test, based on what it said in Merck, is of general application. I think that's become clear. That's the test we've got. That's the test we've got to work with, particularly in relation to 3A. And it applies irrespective of whether or not the product is expressly mentioned in the claims. We now have two situations, one where it was claimed, one where it's not claimed. And in both instances, just being able to identify the combination wasn't sufficient. And as I've stated already, express mentioned in the claims doesn't meet the first limb of the test, which I've kind of highlighted here in yellow as a reminder to follow through. Now, before we look in a little bit more detail at what fall under the invention means, it is quite important to take account of this comment from the Advocate General's opinion, which I think maybe not everybody has realized. But the Advocate General made it absolutely clear that there was a problem with the English language translation, and he looked at the original French language, which was the version that the judgment had been written in and drafted in. And when the original decision came out, there was a reference to the technical specifications of the invention. And of course, the technical specifications of the invention, well, the specification is just the actual document itself. It doesn't have, the word specification doesn't usually have meaning in terms of understanding what the features are, the characteristics, or the elements that make up the invention are. And he picked up on this point and made absolutely clear, because the paragraph from the Advocate General's opinion, in the original term in the decision in Teva was characteristic technique. That is to say, technical features, which is much more in line with what we would understand, at least as patent practitioners, in terms of the actual elements, the things that are described in the patent as being key to working out whether something has the same features as the invention claimed or not. So to determine whether a product is protected by a basic patent, it is necessary to identify in the claims, reading them in light of the description and the drawings of that patent, the subject matter of the patent, the invention and its technical features, which is a narrower concept than the extent of the protection granted by the patent around that subject matter. So I think this is the link here. So extent of protection would be, I think, what we mean by infringement. It's the patent gives an area of protection, and particularly with things like the development of doctrine of equivalence and stuff like that, that protection can be broader than the definition of what the subject matter of the patent is, the actual technical features, how you work out whether something has the same features as the patent or not. And so this is I think quite important in being able to properly understand what falls under the invention means. So it is fair to say that in the Merck cases, there isn't a lot of detail about what falls under the invention means. But I think we can say the patent specification has to disclose how the product that is claimed constitutes a technical feature required for the solution of the technical problem disclosed by that patent. Now, I think this is maybe a more comfortable type of discussion or analysis for patent practitioners to actually get to grips with it. And of course, there can be an argument over whether something has the same technical feature or the significance of a particular technical feature in relation to the product and meeting the requirements of the invention. But that's an argument I think that we can better get to grips with. And the specifications and the drawings provide information in relation to understanding the technical features, and the judgment did make reference to the EPC 2000 because, of course, there isn't a community patent as such. The granting of patents in the European Union, even with the UPC, is still done under the EPC 2000. So if the first part of the Teva 1 test is not met, so if it doesn't fall under the invention, so the court said this would make it possible to obtain an SPC for a product which, although claimed, is not the result of the research which led to the invention protected by the same patent. And if we remember, going back to the recitals, in a sense of the SPC regulation, this is one of the key things. What is the invention or the research that had to be carried out to produce the product, which was then delayed because you had to get the necessary regulatory approval for the medicinal product. But what was that original invention in the first place? So it did go on to say a little bit about what extra does the combination need relative to the individual product. And I think basically this can be summarized as it needs to be synergistic. The combination of A plus B needs to be different than A plus B on their own, just being added in together. So there has to be some, it's more effective at a lower combined dose, something like that. Now, this raises an interesting question insofar as, regulatory approval for combinations doesn't necessarily require synergistic effect. It just requires a better risk-benefit ratio. So there you can get approval for a combination which might not necessarily involve synergism. But in order to have the protection for the SPC and extend the patent, it seems that may not be enough in its own right. You need something extra. And the example that was taken on was synergistic. And I suppose we do have some experience with recent case law at the EPO in relation to understanding how to determine synergism and work out whether something can meet that standard or not. But clearly, it is setting a higher bar, I think, for a combination of A plus B over and above what A and B do. And in stating this point, what the judgment says in paragraph 71, the objective pursued by the regulation of encouraging research by allowing the investment put into that research to be covered while taking into consider all the interests at stake by permitting grant of SPCs only for products falling under the invention covered by the basic patent. So you can have one go, and if you have another for the product that falls under the invention in the terms that the court is talking about, if the second product falls under that invention as well and can be shown in that case, you could acquire the SPC. So it's linking it back to this idea of what was the research that led to the innovation in the first place, which ultimately was the reason why you developed the product and had the delay that led to the need for the SPC. So I've tried to summarize this here. I think you're more likely to get your SPC for A plus B if it's shows a synergistic effect, or if it's got some new feature in its own right. If you find that it can do something new, then you can have a separate patent for A plus B in its own right and get the related SPC. So that in a sense is meeting this requirement for what it's innovative in its own right, and it's only clear from considering the description of drawings as well as claims. I mean, in the Merck patents that was the subject of this referral, there was a reference to the combination, but there was very little discussion about what the particular features of the combination were and how it carried out the treatment of reducing cholesterol. I think was the Irish case, and that was determined not to be sufficient information to justify the grant of A plus B in its own right. Where you're going to run into problems, I think, is A plus B, where it's just an additive effect, even if it's I suppose if you get if you can formulate it, I think while formulating it in a form that's easier to take may well meet the regulatory requirement. It might not be sufficient to get to meet the requirement for a separate invention or a contribution in its own right. So I think that can be quite a tricky area. I think I would relate this back to the point of evergreening. I think that's the concern of the court here. They see that, well, if I have an SPC for A or an SPC for B and I want A plus B, and there's no particular change or benefit for A plus B, then that's a form of evergreening. And that has been at least a consistent message going right back to the start of the regulation, that this is what we're trying to avoid. That's what the court is trying to avoid. Because in a sense, they're saying the innovation in that context still relies on A or still relies on B, and there's nothing coming from the combination. So I think I'll leave it there, and I think hopefully that gives you some take homes that you can take in relation to the combinations. Like, clearly the bar for the combination is set higher now, and synergy is quite hard. And I will just quickly move on to the 3C point. And it said here, the test for Article 3C is basically identify the product for which the SPC application has been applied for, right? It's as simple as that. So what have they applied for the SPC? And has that product already been the subject at the date of application in SPC in the member state in which this application is submitted? So there's no element of what the product is. It's purely and simply, can you find that product anywhere else that's been granted an SPC? So in a sense, that's for it's already been granted, and if I'm looking to get the same product, even if it's for a different use at a later date, I'm going to run into a problem. It's a pure identification case. And I think the court was pretty explicit in saying that you shouldn't mix up the considerations for 3A for 3C. That's probably one of the most explicit things, and refers back to my slide earlier on about how 3A and 3C operate. That one is about a material question, and the second is about a temporal question. And then finally, I just wanted to include a few points that I think are worth keeping an eye on going forward. I think there is the proposal in the EU Biotech Act, which just came out last year, for an additional 12-month extension to the SPC for biologicals and advanced therapeutic medicinal products. There'll be a number of other requirements, like you must have the manufacturing step in the EU, and you must be doing clinical trials in at least two or more of the member states. But like an extra 12 months, given the value that the 6 months pediatric extension has been to lots of products. This is quite a significant proposal, and it's certainly generating a lot of debate for and against at the moment. The new pharma package from the EU, which is been published now and is going through the final stages, it does change what the regulatory data and market exclusivity protection you will get. So it means that you have a much more complex question to answer in your pharma strategy when you're trying to work out, will I get a better protection from my SPC or from my data protection? And I think you'll need to consult somebody that's good on the regulatory data side and the market exclusivity side, as well as on the SPC side, to answer that question. And then lastly, slightly more speculative and slightly more longer term, I think is what happens with medical devices and drug device combinations. Because these are becoming more and more complicated and the approval is becoming more and more complex. So maybe there is going to be a trend where the need for an SPC or some type of related protection in relation to this area is going to become greater. And this is maybe a question for the stakeholders to start keeping track of this and maybe to feedback their experience problems, because that's how the SPC for the plant protection products came out after the SPC for the medicinal products did back in the early 90s. And so I'll leave you with that thought in terms of how things can be influenced going forward. So sorry, I've gone slightly longer than I expected. Apologies for that. But as you see, I get kind of wrapped up and carried away by this subject. So hopefully I've given you some food for thought, and I'm happy to take some questions.
Thanks very much, Lawrence. That was an excellent explanation. And there's nothing to be ashamed of being both passionate and knowledgeable about a topic. We have got some time for questions now. So if you put them in the chat panel, which you can see at the bottom of your Zoom screen, I'll put them to Lawrence. I've got a number of questions came to me as I was listening to your talk, Lawrence, and I'm going to ask them in order of increasing horribleness, if I may.
Okay.
So the first question that affects my own practice and in-house IP departments is what lessons do we need to take from these decisions when we're planning the initial filing strategy for protecting a novel product? So it's very common practice when you're applying for protection for a new chemical entity, let's say, you would, depending on the therapeutic area, apply or include claims directed to a combination of the novel product with other products in different therapeutic classes.
Mm.
And these are largely a matter of speculation.
Yeah.
And it's to prevent horrible people developing your combinations, including your own product.
Mm.
But what normally happens is that you end up tripping over your own feet and spoiling a perfectly good invention for yourself later down the line. So I think what you've said from the Merck decisions, it leans even more strongly to being quite circumspect in the initial filing, and then genuine synergistic combinations, if and when they are discovered, they should be considered for their own protection under a different family of applications. Would that be how you would advise clients, or?
Yeah, I think I'd be more inclined to do that. I think the idea of a laundry list, which you would say you could use A in combination with these different elements of B. So in a sense, you're trying to have something which would justify a claim, is probably not good enough, because the question that will be asked then is, what's in the patent that actually talks about how those combinations work?
Right.
And so the question would be, do you have some data, or do you have something specific that says how A and B work together?
Yeah.
And what that motivation is. And it might just be it might just be something. I mean, there's been some recent EPO case law where the EPO, the patent talked about a combination, and the prior art was another combination. But the reason why it met the inventive step and the sufficiency requirement is that the combination of A plus B was significantly better than A plus C. And they'd done some data just to compare A plus B and A plus B and A plus C. So
Okay.
your point about, you have to be a little bit more focused on what the combinations are, and maybe waiting until you get a clearer idea about what those combinations might be and the features they have is probably, I think, the take-home message in this instance. I think the days when you could just have a big laundry list of what might work in there, and if I go back to some of the earlier cases which talked about, you added in things with a diuretic in order to make them easier to take. That I think is over post post Teva and post the two Merck decisions.
Excellent. What is quite interesting is that the way that the whether the combination falls under the specific subject matter of the invention, it's almost akin to the problem and solution approach employed by the European Patent Office, and I think you kind of alluded to that in your talk.
Yeah. I think clearly the court is saying, well, we don't have any community requirements that we don't have community legislation for a patent. So all the member states are involved in the EPC. Therefore, they're not, going back to the earliest case law with pharmacia and earlier cases like that from the early 90s, they said, well, in the absence of a community system for the patents, look at the EPC. And so the problem solution approach, is probably the most common way of dealing with that, and certainly looking at things in terms of what the technical features are and analyzing what those are and what the closest prior art covers is probably the most useful way of dealing with it.
Interesting. And I was also struck by the point that obviously when we're filing a patent application covering a combination, you're always looking for synergy of some kind, but synergy can be quite a broad term. So you can have synergy in the sense you would expect that the two products co-administered achieve a better therapeutic outcome. That's classic synergy over and above an additive effect. But you can also have synergistic effects, such as the combined product is easier to manufacture or easier to formulate or more economic. There can be sort of non-therapeutic technical effects. And it will be interesting to see how those are handled when you're applying for an SPC.
And you see, I think, all I would say in that instance is you might have to be prepared. You might have to take a punt, and you might have to be prepared for some tricky discussions with the granting authorities, because I think the initial reaction would say there isn't synergy here in the classic sense. A plus B, it's not a lower concentration. You'd have to argue what is the difference, for instance, because if it's a better, it's easier to make, but then the question would be, well, surely it's easy to make A on its own, and surely you can use the same thing. So it has to be genuinely something about the combination. And in that instance, then you might, as the applicant, have the choice of, is there something here that justifies getting a patent in its own right? Because if I can get a patent in its own right, then it's you can refer to that as the basis of the SPC, and it becomes a simpler situation. So it might be how you argue and show that A plus B is different to A and B, and I use that broad term as broad as you would like to do it, and that's why the SPCs are quite valuable. It might well be worth taking seeing if it's worth exploring how far you could go with that question. But I think there's certainly an element of risk involved in it because it would I think most of the granting authorities would say that's not synergistic as we understand it, and so you'd have to at least be prepared to explain how you thought the combination worked differently and it still fell under the scope under the invention um, if there's an earlier SPC for one of the components or both of the components on their own.
I mean, you said the magic words yourself. It's always worth taking a punt, and that is true in the area of SPCs more than any other area of IP law.
Hmm.
And that's why there are so many decisions because the rights are so valuable that
Yeah.
even if you can get an extra day protection for a blockbuster drug, it's worth appealing it all the way up to the CJEU.
Yeah,
Um,
and you have to invest so much money in getting the clinical trials. So is the cost? I suppose this is more one for the practitioners. I wouldn't know this given I was on the granting side rather than on the practice side. But is the cost of the litigation relative to what you spent already worth it? Neurum is I think a really interesting case in point because Neurum was refused before the patent office and it was refused by the patents court, and it went to the Court of Appeal, and it was the Court of Appeal judge who said, I'm not sure about this. Second medical use is, you can get a patent for it in its own right. Surely it should be worth SPC protection. And so we had 10 years of applications where you could have a separate SPC for the same product for a new use if there was no overlap or no link back to the use that had been approved originally. But then the court said, actually, no, we've got to interpret products strictly. And so, but clearly, it made sense to Neurum to try that, and it gave people lots of other opportunities. But I think what you have to realize is that the case law can change, and you might, there was 10 years between Teva versus Gilead being argued in the UK office and Teva versus Gilead being going all the way to the Court of Justice of the European Union. And originally, Teva versus Gilead was granted on the basis of it was just sufficient to have a claim that said A plus optionally any other ingredient. And that was enough. It was disclosed in the claims. You didn't have to have much information in the patent itself. But 10 years later, then the Court of Justice says, no, you must have information in the patent describing why that combination is unique in its own right, if I put it in those terms. And so that means if you're operating in that marketplace, you are now in a different position. And that can affect you. So I suppose in the same way that it's worth taking a punt at the start to see if you can those areas that are at the borderline or at the crossover point, you can see what you can get your SPC for. You might have to accept that things could change equally, and it might be a little bit harder to defend those SPCs in the future. So I think there's it's a balance of probabilities test, unfortunately, and
yeah.
so certainty in this area is not easy to come by, and it may well be that you just need to take as much advice as you can from a few different sources, and then work out whether partly you've got the money in the bank, and partly whether you've got a strong enough case that you think can get you somewhere in terms of getting it granted.
Yeah.
I mean, Halozyme, although that's a pending referral before the Court of Justice of the European Union at the moment, where they have a combination of an enzyme plus what is defined as an excipient in the marketing authorization. But they're saying that the excipient has characteristics that make it act like an active ingredient. So surely that is a combination. Well, it's while it's going through the Court of Justice and while it's been going through the litigation, you could say other people haven't been able to come into the market, or other people are uncertain about whether to come into the market. So is that ongoing question, even if it's not resolved, still valuable in the wider commercial strategy that you're trying to carry out as a particular company? And I'd leave that with those that would have to make decisions in relation to that. But certainly there's a number of different ways in which, these kind of questions can be answered or approached in terms of working out what's of benefit to the company or the people that have the patent and are making the SPC application in the first place.
I mean, you touched on the point that expert advice is essential in this area, and you are obviously too modest to promote your own consultancy services, but I am not too modest to do that on your behalf, and I know that you have your own specialist consultancy in the area.
Hmm. Well, I appreciate that. Thanks, Andrew. But yeah, I mean, I find the area interesting, and equally, lots of questions that come up in this area. It's very hard to give a black and white answer, but in looking at what the options are and discussing what the options are, you can certainly firm up your ideas and your approaches. And certainly, as a hearing officer, that's what I found worked, because the examiner had one view, the applicant had another view, and you had to go back to the case law, you had to go back to the arguments that were made, and work out, what was the best outcome. But again, it was a balance of probabilities, and I suppose all I would say is that I tended to most of the decisions that I issued that were appealed were upheld. So that was a compliment to me. I had to, I knew they would be scrutinized and they would be challenged, but most of them were upheld, and those that were overturned, some of them were just done. Like I issued the first decisions on the pediatric extensions, and a lot of it was about how that actual regulation worked in terms of timings and when the rewards would come in. And so the court basically said the office was taking too strict approach. You need to take a more liberal approach. But then that provided clarity. At least after that point, we knew this was allowable, this wasn't allowable. You could provide all the information right up until the expiry days of the SPC, rather than when you made the application 2 years or 6 months before the expiry of the SPC. So in that kind of situation, I would hope that I would be able to give people a pretty informed decision, or at least some ideas to go away and think about, and help inform their strategy on that basis.
Yeah, you have got a unique experience. One thing that has occurred to me, I mean, SPCs is quite a huge topic, and you focused on one particular aspect today. Once I send out the follow-up materials to the audience, if people are interested in another aspect of SPCs, or perhaps a more general talk about SPCs, would you be happy to come back and give us one of those?
Yeah, certainly. Certainly,
Yeah.
I could. Yeah, that would be I just find the topic interesting, so I'm more than happy to come and talk and give a more general introduction to kind of how it works, and the kind of things that people need to take account of. Certainly.
That would be brilliant. Okay, I've got one final question to leave you and perhaps the audience with before we go back to sweltering in our offices. What about a three-way combination? So let me give you the hypothetical situation. Compound A is as old as the hills, and that's been on the market for years. Combination of A plus B has its own marketing authorization and is covered by an SPC and its own patent, which has synergy and whatever else it needs. There is a subsequent product, A plus B plus C, which is entitled to its own marketing authorization, is further protected by a separate patent. Would that be possible to cover by a separate supplementary protection certificate?
Well, if it's got its own patent for A plus B plus C, and it's sufficiently distinct from A plus B, and you'd need to compare the two patents in relation to that. So, then it would certainly, I think, be entitled to its own SPC. I mean, the Medeva and the Georgetown case law, which was to do with the vaccines originally, was saying that, if you have a 10-component vaccine and your patent protects A or A plus B, and your marketing authorization includes A or A plus B, that would be a sufficient match between the patent and the marketing authorization to get your SPC. So the determining factor would be the patent in that instance, rather than the marketing authorization. So if you can show that A plus B and A plus B plus C are distinct and have their own patent, then on the face of it, I think you'd have quite a reasonable argument to say you're entitled to a separate SPC. Now, if A and A plus B and A plus B plus C were all things for treating cancer, or the same condition, then you might have a trickier question to resolve, because you know that A works for cancer. So how did you get the patent for A plus B? Well, if there was genuine synergy and you're still treating cancer, okay, that's fine. But then if A plus B plus C, if you say that's even more synergistic, then you're having to show that it's different to A plus B and A, because the protection for A and A plus B has already, if you like, taken up some of that area. So that would, I think it would depend on what the actual patents said and how closely related they were in that sense. Whereas if for some reason, I don't know, like A was, say A made it much easier to give a lower dose of B plus C, then that might be quite different to what was happening with A plus B. But if A was allowing you to give a lower dose of B, then the argument might be, well, that's the innovation that you got for A plus B. So I think it would probably mean that you'd have to show exactly why A plus B plus C was different to A plus B and A in order to get it. But if it has a separate patent in its own right, that's probably a good place to start.
In fact, at the EPO, the situation of three-way combinations is even more challenging than you alluded to, because you need to demonstrate synergy over each of the two-way combinations. So you need to demonstrate synergy over A plus B, A plus C, and B plus C.
Yeah. Yeah.
So
Yeah.
yes, it's
So it's the same thought process, isn't it? Isn't it?
yes, it is.
Why is the three-way different to any of the two ways? Because if
Yes.
one two-way works, okay.
Yeah.
That makes sense.
Well,
Um,
that's fantastic. We're coming up to the hour now, and we've taken up a lot of your valuable time. And I thank you on behalf of the audience, Lawrence, for sharing your expertise with us. We're going to distribute a recording to the of the webinar in case you have colleagues who are interested in this topic who were unable to attend. And over the coming weeks, Lawrence and I are going to prepare a white paper as well. And in the meantime, if you have any topics for future webinars, whether SPC related or otherwise, please let us know, because we're always very keen to generate new educational materials that are useful to our clients and our friends. So that's just about perfect in terms of time. So Lawrence, thanks once again. It was a really fascinating exposition. And I wish you all a very good weekend, and I'll see you at the next event.
Indeed. And thanks again, Andrew. It's been a really enjoyable seminar. Cheers, everybody.
Bye bye. Bye.